Okay, well, hopefully everyone's had time to get in. So let's officially start. Hello and welcome to our quarterly sample policy update series. We're so happy you're joining us for our discussion today that focuses on the December policy packet. Next slide, please. Before we get started with the content of the policies, let's go over the layout of the webinar. We will start with housekeeping and presenter introductions. Then we will move on to a brief poll to learn more about who is attending the webinar presentation. After that, we will learn about the policy updates. We will then conduct another poll where we are hoping for feedback as to how we are doing. And please know that there will be time for questions and answers at the end of each section, as well as at the end of the full presentation. Next slide, please. Just a few housekeeping tips. So please use the Q&A feature to submit your questions. This is located on the ribbon below the speaker. The chat feature for most of the presentation will be turned off. However, we are going to turn it on during the polls in order for you to be able to respond that way. And your questions will be answered either in the Q&A feature itself in writing or live by our presenters. And please know that all attendees will receive a link to the video of this webinar as well as to the slide deck. Next slide, please. And now for an introduction of our knowledgeable and thoughtful panelists. So we have Joshua Daniels, who's the Chief of Policy and Government Technology Services, Bob Tuerck, who's Chief Legal Counsel, District and County Office of Education Legal Services, Meghan Rustle, who's a Senior Policy Manual Writer, Dustin Bindreiff, who is also a Senior Policy Manual Writer, and myself, Barbara Laifman, who's the Director of Policy Manual Development. Next slide, please. Before starting with our first poll, please know that the purpose of this poll is to gain insight into who is attending the policy update webinars in order that we can focus our webinar material and presentation appropriately so that it is most meaningful to your positions within your respective districts and county offices of education. So Josh, if you could please open the chat. And we're going to start with kind of a fun one since we actually haven't done anything like this yet in our presentations, and probably then the first time for you guys too. So if you could reply in the chat, who is going to win the Super Bowl? A, 49ers, B, Chiefs, C, Taylor Swift. And you're welcome to put in the letter or spell it out however you would like. Wow, well, I'm looking at the chat. It's actually split really evenly. There doesn't seem to be a winner so far. Thank you all for responding, getting lots and lots of responses. Yeah, and it's really, I mean, I can't tally it. We're going to use a different method next time so that we can really come up with more accurate responses, but it's a pretty even split. So thanks for doing that. Let's go on now to our more official poll about who's attending. So next slide, please. So what is the role in your district? A school board member, B, superintendent or district administrator, C, executive assistant, or D, other. And again, since this is going into the chat, we will have this, and we will, this is not a silly one. This is, and we're going to look back and get an accurate count so that we're sure that we're serving you the best we can. So thank you so much for responding. Next slide, please. Bob will start off by giving a brief overview of CSB District and County Office of Education Legal Services and what these services offer to districts that subscribe.
Thank you very much, Barbara. First of all, I just wanted to, like Barbara said, just describe to you guys really quick what is legal services for those of you who don't already know about it. And then I'll tell you a little bit about how it relates to policy and why we're talking about it in this webinar. So first of all, legal services program we started about 2 years ago that allows CSBA attorneys to provide direct legal advice and counseling to our members that subscribe to the program. As you can see on the slide, there's sort of two main components to it. The first is that you have access to a legal resource library. And this has literally tens of thousands. I think actually we're over 12,000 now, collective bargaining agreements, MOUs, salary schedules, and a searchable database that allows you to use that for your collective bargaining needs, for preparing for negotiations, knowing sort of where you stand with your neighboring districts in terms of recruiting and retention of staff. So it's a great negotiation tool and staff resource tool for you. There's also additional resources on there, like our monthly Lunch and Learn webinars get posted there. There's case updates, templates, all sorts of self-help documents that are available 24 hours a day for anyone who is a legal services client. But the most important part of the program is it creates that attorney-client relationship that allows the attorneys in my department to act as your legal counsel, right? We can provide direct, confidential legal advice and counseling. And we work on just about anything that doesn't rise to the level of actual litigation. We're not staffed for that, but whether it's going to be custom policy writing, assistance with HR documents, contracts, PRA requests, policy writing or implementation, all those kind of things we can assist our clients with. So in a nutshell, that's kind of what the program does. And the reason why we're here today to sort of participate in this and why we've been part of these webinars is that we are, like I said, able to create some unique language for you on your policies and assist with the implementation. So as Josh will talk about here in a little bit, our CSBA sample policies are exactly that, sample policies. You should be customizing these and reading them, making them suitable for your local practice. And sometimes that requires some legal advice. We know a lot of our members will turn to their attorneys and legal counsel for that, which is wonderful. But we wanted to make this available for you as well to contact our department to help out with that. And the reason being for that, right, we're close to the source. We're part of the process of creating these policies. So we're uniquely situated to know the history and the reasoning behind the sample language, which helps us to create more efficiently customized policies for you. So our team can assist with that. And the other thing to note is that we can assist with implementation. We've been doing quite a lot of this in the last couple of weeks. And the lesson here is, you've heard the term look before you leap. When it comes to policies and implementation of policies in particular, it's really ask before you act. The number of districts that we have seen that we've assisted after they've acted before they asked a question about implementation, and we'll talk about that in a little specific circumstance today, is growing. And that's unfortunate because if you ask for assistance with learning how to implement, or if you're not sure about what policy language means in terms of implementation, if you ask before you act, you're going to reduce your risk of liability and consequently your legal costs. So it's a lot more efficient to just pick up the phone and give us a call, and we'll be happy to help you with interpretation of any of the policies. Next slide, please. But here's the best part. I'm sure you are all very wary of the budget situation that we are facing going into next year for California. And for our legal services program, it's already a really cost-effective program, but when you combine it with Gamma Policy, which many of you already have Policy Plus that are on this webinar, you save even more. So if you have legal services, when you sign up for the program, you automatically get 3 free hours or 3 hours of attorney services free of charge. And then if you have Gamma Policy Plus, on top of that, you get an additional 2 hours that are dedicated specifically for policy assistance. So that's up to $1,000 of attorney advice and counsel free of charge. And for the vast majority of school districts, the fee to sign up for legal services is less than $1,000. So it's kind of a win-win, especially this time of year when we are prorating the sign-up fee. So for many districts, we just had a district sign up last month. They paid $108 to sign up, and they received $1,000 of legal advice. So it's definitely a beneficial program, especially as we're looking at some budget crunches. But I am going to stop droning on about this program and allow Josh to get into some more substantive policy issues.
Okay, thanks so much, Bob. Contact information for CSBA District and County Office of Education Legal Services will be provided at the end of the presentation, which will be useful if you're interested in subscribing or learning more about CSBA's legal services. Okay, next slide, please. As an introduction to the updates, let's look at a brief description for each of the documents. It's kind of a basic review, but maybe for new board members or those who, you know, aren't as familiar with it, we'll go through some of the, not really a definition, but a little bit of an explanation for the purpose of each. So there's board policies, and in this, the governing board legislates by way of board policies, which articulate the policy direction of the district or county office of education. For administrative regulations, the superintendent implements the board policies by way of administrative regulations, which provide the necessary details while staying within the confines of the applicable policies. We have exhibits, which are really helpful implementation tools. It can be forms, notices, and other tools consistent with the policy or administrative regulation to which it relates, and can be useful, especially as a starting point for some legally required forms and notices. And then we have board bylaws, which are specific board policies that provide the rules and procedures that the governing board must follow. And just to know that policies is an inclusive term we use for policies, regulations, exhibits, and board bylaws. So just so when we refer to policies, know that it can encompass all of these. It might not necessarily be just, as we call a BP, a board policy. Okay, next slide, please. Well, we're going to also do a little review of the numbering system. I'm not going to necessarily go through each one because you can see them written out. The only one to provide a little more explanation about is the 4000s, because those are coded a little bit differently. We have the 4100s, which are for certificated staff, the 4200s, which are for classified staff, and then the 4300s, which are for management and supervisorial staff. And sometimes they're the same for all three. We'll have one policy with the same wording for all three, and we call these triple coded. Sometimes we'll have for two, and those will be double coded with one of them being drafted separately and written separately. And sometimes all three are different. Okay, next slide, please. And we're going to just look at some general guidelines to think about when your board or you know, when the superintendent, when you're adopting policy. Just remember that any of these documents, whether it's the policy, the regulation, the board bylaw, or the exhibit, that these are samples. So we're hoping, the hope is that it's kind of like a template to serve as a starting point for your district or your county office of education. And we're hoping that when you review, you kind of make it specific and special to your district, because all of our districts and county offices of education have something very unique and special and that we're very proud of. And that should be reflected, hopefully, in the policies themselves. And just a little caution that the policies have gone through legal review, but to remember that they do not actually constitute legal advice. And we try to stay as current as we possibly can, given that we will see on the next slide that we have a huge manual, but to remember that they can become outdated. So we try our best, but we can't promise that it's totally up to date for each one. Also, there's notes, which many of you have probably seen, which are embedded in the policy materials. Just remember when you go to adopt them, that the notes are not the policy language itself. They're simply a note and explanatory information to explain what the body language of the policy states. Okay, next slide, please. All right, what you'll see here is a complete list of the policies that were updated with the December packet and categorized by section. We're doing a little different this time. We'll be highlighting and going into more depth on one policy per section. If you have any questions on any of the policies that are not being highlighted or any of the materials discussed today, like I said before, we can address them at the Q&A after each section or at the end of the presentation. And we will also provide contact information for further inquiries. Next slide, please. Finally, what you're here for, highlights from the December policy packet. Our presentation is divided into 4 categories: student health, which will be led by Dustin; student opportunities and achievement, which will be led by Meghan and Bob; business operations and accountability, which will be led by Josh; and board governance, which will be led by Josh and Bob. And again, time for questions and answers at the end of each section, as well as at the end of the presentation. All right, so let's turn it over to Dustin for a discussion about student health.
Thank you, Barbara. So there were, in the December update, there were 3 policies related to student health that we updated. Administering medication and monitoring health conditions went through some pretty significant revisions, so I want to go in those in more detail. But we also updated the policy and AR related to bullying and comprehensive health education. Next slide, please. Regarding, there were a number of bills impacting 5141.21, administering medication. Some of these in minor ways, others requiring extensive revisions. They begin with Assembly Bill 1810, which specified that upon request from a parent, an administrator may designate a volunteer that has been trained to administer anti-seizure medication. This bill also details requirements for posting the request for volunteers, which must be done at least once. It also explains that the volunteer may rescind their volunteer status at any time without repercussions. 1810 also details annual and refresher training requirements for volunteers. It also explains in order to administer anti-seizure medication, the school must obtain consent and create a seizure action plan with the parents or guardians. Additionally, the bill requires the district to inform the families of potential disability eligibility related to seizures. So this bill also details the requirements for notification and documentation if the anti-seizure medication is administered. And then it also provides volunteers liability protection for administering medication. So it's a pretty comprehensive description in 1810 that we incorporated regarding anti-seizure medication. Similarly, Assembly Bill 1283 provides guidance allowing the districts to provide emergency stocks of albuterol inhalers, which can be used by school nurses or trained employees who have volunteered. This bill is going to provide similar notification requirements for requesting volunteers, details about annual and refresher training requirements, and it allows the school nurse or other qualified person to obtain a prescription for epinephrine or albuterol inhalers by an authorized physician. It allows the district to accept gifts of albuterol inhalers, and it provides similar protections to volunteers when administering albuterol to students. Next slide, please. A couple more bills related to administering medication. Senate Bill 114 provides funding to County Office of Education for the purpose of coordinating the purchase and maintaining a stock of emergency opioid antagonists, which the county offices can then distribute to districts within their jurisdiction. Districts that receive these antagonists from the county office are required to distribute at least 2 units to each middle, junior high, and high school and adult school in the district, and to restock each unit prior to expiration or after its use. An important distinction is if the district elects to receive these opioid antagonists from the county office, each school site must identify and train at least 2 volunteers to receive annual and refresher trainings. The legislation also details that opioid antagonists have similar training, posting, protection, and volunteer requirements as the other medications discussed previously. Similarly, 5141.21 permits school nurses and other qualified individuals to obtain a prescription for an opioid antagonist. The key focus I wanted to share with in this policy is whether you're considering providing albuterol, opioid antagonists, or anti-seizure medication, it's important to review the specific requirements for each of those in the policy. Each of these has slightly different parameters related to notification, training, and documentation. So it can be confusing and potentially dangerous, making it important to review the guidance for each medication. Next slide, please. So regarding bullying, we updated related to Assembly Bill 1078, adding a policy, as you can see there, applies to governing anti-bullying, applies to governing boards and superintendents as well. Additionally, we added some language in the notes and referenced some resources recently come out from the Surgeon General and the U.S. Department of Education that you can see here related to mental health and an epidemic of loneliness, and provide some warnings and guidance related to social media and youth mental health. We also similarly updated providing the resource from the CSBA on school safety and cyberbullying. Additionally, we updated those for some AB 2879 related to cyberbullying and suspension and bullying. Next slide, please. Finally, the third one, comprehensive health education. Similar updates to the previous one. We added some notes and language referencing those guidance documents about loneliness and student mental health. And we also added this requirement related to mental health instruction. If the district's providing other forms of health education to middle and high school students, then they now need to incorporate some form of mental health instruction in that. So what you see in this student health section is mental health continues to be a priority for districts, county offices, and the state. And so these are policies we've been updating and working to provide districts with resources to. Next slide, please. Barbara, were there any questions?
Yep, we're going to check right now. So thanks so much, Dustin. Yeah, and it's our time for questions. So it looks like we have a couple. One is, does AR 5141.21 only address the specific medications that you mentioned, or does it cover any medication that could be legally administered?
So it covers broader scope of medication delivery in general. So it does discuss broader parameters. The reason I focused on those three is the recent legislation added some specific requirements related to administering those medications. So there's general parameters and guidance about notification, training, safe storage, and what have you for all forms of medication. Those albuterol and the opioid antagonists and anti-seizure medications just had some specific additional requirements that we wanted to make sure districts are aware of.
Great, thanks, Dustin. Okay, two more questions. One is, if we have a K-8 school, can we provide emergency opioid antagonists at that K-8 school?
To my knowledge, the law does not prohibit it. So the legislation is focused on secondary schools. There was no mention in the recent legislation about providing those free opioid antagonists to elementary and primary schools. So that would be a local decision. If you look in the policy, there are training notification requirements related to opioid antagonists that if an elementary school wanted to stock some, they would want to make sure they are in compliance with.
Thank you. And yeah, and it's always a good idea. Can always check with your legal counsel or with Bob's group here at CSBA to confirm. But thank you for that. And our last questions on this topic is, do we have to negotiate the updates to AR 5141.21 since it could involve new duties for staff?
I'll jump in on that one if you want, Dustin. That's a great question. Generally, it's going to be like the administration of other medication, right? So you're going to want to make sure you have training, but if you're going to have somebody administering medication, hopefully it's somebody who's already gone through some training, right? And they're like your nurse or your campus health providers, right? That can assist with that, just like they would be administering any other medication. So to the extent that it's going to create some sort of change in job description or that kind of thing, yeah, you might need to consider that. But generally, I think you're going to be fine in terms of the bargaining in this because of who's going to be administering the medication. The other thing just to know on the last question, the training is definitely important. Narcan, the administration of Narcan, and we have some resources on this in our legal resource library, has generally been a pretty benign thing to administer in terms of side effects. So while there's always risk associated with administering any kind of medication or dealing with medical situations, so far, the prevailing sentiment seems to be that it's a fairly safe thing to administer to prevent overdoses. So your risk of liability there is going to be less than it might be in other situations. But again, we have resources in our legal resource library, and we'd be happy to answer any questions about that specific to your district offline.
Okay, great. So thanks so much for the really good questions and our responses. And now we would move on to the introduction of Meghan and Bob, who will lead a discussion about student opportunities and achievement.
All right, so we're going to be focusing first on involuntary student transfers, and then we'll also briefly be touching on preschool and early childhood education, transitional kindergarten, high school graduation requirements, differential graduation and competency standards for students with disabilities, and education for juvenile court school students. Next slide, please. And then Bob's going to kick off our discussion on involuntary student transfers here.
Yeah, so this one, thanks, Meghan. This one is a great cautionary tale for everyone, really everyone on this call, because it really speaks to the importance of carefully reading policy and also careful communications, right, in terms of just how you're drafting or communicating things. So for literally everyone on the call, this one is a great learning opportunity. So Education Code 48929 allows for the involuntary of students under certain circumstances, but it comes with a particular due process rights that need to be adhered to and followed. And this was all included in 5116.2. But what we learned from a few districts out in the field is that in some instances, the policy was being misread. And it was being misread in a way that those districts thought they were permitted to transfer students involuntarily without due process to a county school. That is obviously not the case. And so we, as soon as we learned about that, we wanted to make sure that we addressed that to make sure that the policy itself was even more clear. Now, the policy was accurate, right? It did include the correct language in there. But it had a paragraph which was essentially stating when a student is involuntarily transferred, the superintendent or designee needs to provide timely written notification. And then the following paragraph clarified when it was that a student could actually be transferred out of the school district, and that involved the specific circumstances. So in terms of the lessons to be learned in terms of statutory and policy interpretation and reading, is that you have to read the entire thing comprehensively, right? You read it in its entirety. So with, just like when we're interpreting statutes, we have to read through the entire statute to make sure that we are catching all the nuances, because often they will refer back to themselves. Similarly, when you're going through your policies, this is a great lesson that you need to read the policies in their entirety. And again, if you have any questions about that, feel free to reach out to us. But it's a lot like those situations where the teacher hands out a test to students. It's 3 pages long, and they say, read the whole thing before you start answering questions. And the very last question says, just write your name on it and turn it into the teacher. It's a similar situation, right? Read it in its entirety before you find yourself doing too much work or getting yourself into a little bit of trouble. But I'm going to let Meghan describe the actual changes to the policy and go through the rest of them for this section.
Thanks for that introduction, Bob. That's really helpful background about why we made these changes to the policies that were made. So I'm going to go through and talk a little bit about the actual changes that we made to the policy. So the first, as Bob just mentioned, we wanted to clarify that the policy only addresses involuntary transfers to other schools within the district, and that if it was an involuntary transfer to a school outside of a district, that would be covered under a separate policy and separate due process. In the policy, we also added that the determination of where to transfer the student should include a review of the programs to which the student may be involuntarily transferred, and also that the involuntary transfers are made in a non-discriminatory manner. Also, that information regarding notice and disclosure requirements was added to the policy. Additionally, the policy was updated to include legal requirements and recommended best practices governing the voluntary and involuntary student transfers that were based on CDE's September 2023 memo that was titled Overuse and Improper Use of Involuntary and Voluntary Transfers. So when we're drafting these policies, we're not only looking at the statutes, but we're also looking at guidance from entities like CDE. And so that's some recent guidance that came out that we've incorporated and added to this policy. Next slide, please. So the policy was also updated to clarify requirements related to the involuntary transfer of a student who has been convicted of a violent felony or a misdemeanor associated with possession of a firearm, transfer to a continuation education program or class within the district, and transfer to a community day school. And again, these are both within the district. And I think it's also important to note that this policy is only a board policy. There is no administrative regulation. So all of these edits were made to this board policy 5116.2. And moving on, we're next going to discuss preschool and early childhood education. And so for this policy, there is both a board policy and an administrative regulation. And the changes to this were stemming from Senate Bill 141. And there's a requirement that if an early enrollment child is enrolled in the district's TK program, that the district is then required to also concurrently offer the child enrollment in the district's CSBA program. And that's subject to available space in that program. And then for the AR, we also updated the AR, and that was reflecting, again, changes from SB 141, adding a definition of early enrollment child, and then slightly making some minor revisions to the enrollment priorities for Part Day CSBA. And there's some new information about forgiving family fees accrued before October 1st, 2023. And finally, we incorporated some new CDE guidance, which was adding some definitions relating to suspension for those preschool programs. And then next we have BP 6170.1, which is dealing with transitional kindergarten. And this is a board policy only, no AR. And then those changes are again coming from Senate Bill 141, talking about an early enrollment child, ratios, and then again, the concurrent enrollment of early enrollment TK student in the preschool program. And those are a lot of the similar changes related to the preschool program are also reflected in the transitional kindergarten policy. And then next we have high school graduation requirements and differential graduation and competency standards for students with disabilities. And the BPs here, and for both of these, there's just a BP, no AR. Both of those were updated to reflect changes from AB 714, and those are some language changes relating to students participating in newcomer program was changed to newcomer students. So we're updating those policies, and also with SB 114 and 141 regarding exemptions from graduation requirements for students with disabilities. And lastly, I'm going to touch on AR 6173.3, which is education for juvenile court school students. So next slide, please. And this one is an AR only, so there's no board policy, just an administrative regulation for this one. And this one was updated to reflect changes from SB 532, and that was related to transfer of coursework, exemptions from district adopted graduation requirements, and an option to remain in school to complete district or statewide course requirements. So I think we can go on.
Next slide, please. So, thanks Megan and Bob so much. And now, like we promised, we have a little time for Q&As on this topic. So gonna look right now what questions we have. Let's start with the first. Looks like we got 3 questions. We'll start with the first, which says, if BP 5116.2 doesn't address expulsions, then what policy does?
So those depend a little bit on which, what type of student you're dealing with. Board Policy Administrative Regulation 5144.1 is suspension and expulsion. It's covered in there, but if you're dealing with special education students, you actually want to look to Board Policy, Administrative Regulation 5144.2. So that's where you would find the expulsion and suspension due process.
Okay, thanks, Bob. Let's look at our next question. And this looks like it's in regard to AB 116. How does the fee forgiveness work? I'm not familiar with this, but does it mean that the district will lose money?
So this is for family fees that were accrued but uncollected prior to October 1st, 2023 may be forgiven and not collected. So again, I would check with your legal counsel before you're going to be trying to collect or not collect fees, but it does sound like that would be permissive, that they may be forgiven and not collected there. And again,
yeah, I'd agree. It's basically a debt forgiveness, right? If you fall below a certain income threshold, then it provides debt forgiveness for those fees that have been accrued but have not yet been collected by the district.
Okay, we'll move on to our next question. Are we required by law to change the language from students participating in a newcomer program to newcomer students? I can actually jump in for this one. I know required by law, this changed. So yes, it's important to change that language because newcomer students actually covers a broader category of students than students participating in a newcomer program. Although it seems like a very simple language change, I do think it will involve a little bit of an implementation change in your districts and county offices. Okay, on to the next. Is there a new exhibit for 6146.1? That's the graduation requirements. You guys want to handle that? I can take that. No, we don't have a new exhibit for that policy. And I'm not sure who sent that question in, but if you could put in the chat, you could add in, is there an exhibit you're looking for or what you would be looking for? Because that could also help us out in our drafting. Your input, the input we receive from you guys is always very helpful. I'm sorry, Bob, were you going to add something?
I was just going to note that policy is probably the most heavily edited policy in the entire manual, right? Every high school has very unique, we have our standard graduation requirements, but almost every high school has something unique that they're also requiring in there. And so that one is commonly edited by our districts, but there's no new exhibit like Barbara was saying.
Okay, and it looks like our last question in this section, asking basically if the statement is correct. So the question is, if you are only a K through 8 district, well, and then you don't need to have these graduation requirements. Is this correct? So in other words, does a K through 8 district need to have a policy about these graduation requirements?
No, these are specific to high school students. So you're welcome to have a graduation policy that would be more of a ceremonial, but you don't have the same mandatory graduation requirements, so you wouldn't need the policy in place.
Okay, well, thanks so much to you both. So next we are going to hear from Josh for a discussion about business operations and accountability. So next slide, please. And Josh, please go ahead with your portion.
Thank you, Barbara, and good almost afternoon, everyone. Good to see some familiar names in the list of participants. Just my screen. Okay. All right, so we are gonna handle 4 policies under sort of the header of business operations and accountability. We're gonna focus on the LCAP, but touch on 3 other related policies. So, the LCAP, of course, is a pretty major policy, and we definitely made some tweaks to it. So some of the more simple changes were the fact that we updated the BP to reflect SB 114 and 141. Those numbers are there just to confuse us. Those include changes to the definition of LTELs, long-term English learners, and also making sure that we consider them a separate numerically significant subgroup that are separate from your sort of traditional ELs. And in case you didn't read it in advance, the new definition of LTEL is someone who has not attained English proficiency within 7 years after their initial classification. This is less on the policy, but just to note that the state board did recently adopt a new LCAP template. So make sure that whoever's in charge of your LCAP, they should be, but is really using the latest template, because you wouldn't want to do all that work and then have to redo it in the new template. Obviously, counties will be tracking on that, but just to make sure you get it in advance. So the sort of prior version of the policy, the headers and the organization didn't fully track sort of the actual process on the ground. And so we made some changes along with sort of adding new headers that sort of in general focus on the chronological process of LCAP development. So, you have your advisory committees, and you develop and you consult, then you adopt and submit, then you can do with revisions, although those are relatively rare, and then how you monitor progress, track complaints, and then if you need technical assistance. So that was sort of the flow. A lot of the substance has been pretty similar, but sort of the organization of it and sort of flow of it has been tweaked to make it sort of track more with how things actually practice on the ground. As course over the years, they have added things. So the budget overview for parents and guardians is this new thing that's pretty important. And sometimes people will say LCAP, but what they really mean is the LCAP, the annual update, and the budget overview for parents. And then sometimes when they say LCAP, they literally mean just this sort of the LCAP, but not those other two. So just to be cautious as you read through and understand it. We tried really hard to be specific in the board policy. But as you think about modifying things or updating yours, just give some eye to the language that you're using and the terms. We also wanted to add some encouragement. This is the basically 10 years since this process has started, to really work on aligning the LCAPs with the other strategic documents for your district or county office. So whether you have an EL master plan or facilities master plan or a strategic plan, whatever it is, right? Really making sure that they align with each other, so that there's coherence and that you don't have one plan sort of focusing on one area and another plan focusing on another area. So then we also updated the AR, similar changes around, LTELs and things like that. But there is one thing that we chose to put in the AR that wasn't in the BP, and that has to do with, so posting the LCAP on the performance overview portion of the dashboard. So as you go into the back end, right, you can, for your local indicators and things like that, you can post things. You want to now post your LCAP on the dashboard. So they're really trying to drive much more traffic to the dashboard. Okay, so this is one of the more substantive changes we made to the AR. So the AR, as Barbara mentioned before, is the implementation document for the board policy. And there are pretty clear timelines for how the LCAP needs to flow. And they even added one most recently around February 28th. But they don't always give you dates. And so the AR is drafted with some required dates in mind, but we also put in some basically dates that we think make sense given how most LEAs typically operate. So you really want to make sure that when you bring this to your board and to your staff, that the dates align with the dates that you all typically use. And I think in general, the recommendation to put those dates in is because it allows everyone to know when something's coming. So you're not constantly hearing from the community about, when is this happening or when is that happening? Everyone is clear about the timeline. So the February 28th date is a date in statute, and it requires that at a regular board meeting, so not a special, but at a regular board meeting prior to or up to February 28th, you need to report on the annual update and the budget overview for parents and guardians at that board meeting. Now, the next sub-bullet, May 15th and May 31st, those are dates that we came up with because again, it aligns with sort of what typically normally happens in many districts or counties, but you should adjust those as needed. But basically, when are you going to get your draft to your committees, and when are they going to get you feedback? And both from the committee, and remember, you have to like respond to those comments. And then when is the public going to be given the chance to submit written comments? So the suggestion is that whenever the committees are required to do it, the public is required to do it. That way you get them at the same time. And then at the LCAP public hearing, so remember, you have to have a public hearing on the LCAP and the budget prior to your adoption of both. That is when the responses in writing would be provided to the advisory committees. And again, just to a note to please, review these dates and modify them to reflect your practice. Okay. All right, so we're going to just briefly touch on a few other policies. This is 0500 accountability, same LTEL changes. There is a new basis for technical assistance. Basically, if you struggle with uploading certain data, they're going to push in and they're going to provide you with TA around that. And then so we had been operating with sort of a separate calculation for DAS schools under a temporary waiver, but that waiver was recently nixed. So moving forward, there won't be that sort of modified calculation. If you're interested in sort of more details about that, let me know. But I just wanted to flag it for you in general so that you have a sense that that calculation will be different. And this one, like some others, is a BP only. All right, so 0520 intervention in underperforming schools, again, only a BP. So this, I mentioned before, that technical assistance ability is expanded as it relates to submitting information. It tweaks it a little bit in terms of what can be provided sort of under the traditional TA when you have low performing groups where there are disparities, and then sort of mentions the CCEE, which actually I used to work for, around to what they will do in terms of consulting and then stepping in to provide support. One last one in this section is 3400 managing a district assets and accounts, shifting completely from the other, the other three. We did incorporate some language around conflict of interest that came out of SB 1439 I guess a year or two ago. And then added direction to the superintendent to just follow GASB and some other direction and standards set by CDE. And that we really want that the superintendent should submit those reports in accordance with this other relevant policy, BPAR 3460. With that, we have time for questions.
Yes, thank you so much, Josh. So looks like we just have a couple of questions on this topic. The first is, why are the district and COE or County Office of Education policies on the LCAP so different?
So I'm curious to know, Barbara and others, because you have some history to this as well. There are some similarities, but there are some differences, and we wanted to make sure that the sort of differences are noted in different policies. But many of the changes are going to be similar. Just because the updates that reflect, like, so 114 and 141, the LTEL differences, right? That applies across the board. So that's, I think, some general sense of why they're different. I don't know, Barbara, if you want to sort of add any further historical context.
Sure. Yeah. Sometimes they do. Sometimes they're very similar. Other times they are a little different, or sometimes a lot different. It can be based on, sometimes there are different laws that apply to county offices of education that are specific to county offices and are different for districts. And the other is there's a different relationship between the board and a superintendent of a school district and the county board and the county superintendent. So we try to be sensitive to that in drafting and draft appropriately for the environment. So those are the two biggest reasons that they tend to differ. And sometimes you will see that they're very, very similar. So, but yes, but we do take particular look when we are drafting policies unique to counties. Yeah. Okay. Our second question is very specific to language on one of the slides. And in regard to the February 28th date about reporting to the board at a regular meeting on the annual update and budget overview for parents and guardians. And the question is, does that begin on this February 28th? Of 2024?
Yes, the law's in effect.
Okay, great. Okay, so that is it for business operations and accountability. So next, Josh and Bob will lead a discussion about board governance, which is our last section for today.
Awesome. All right, before I turn it over to Bob, just give you a quick overview. We're going to focus on 9321, has one board policy and 2 exhibits, and then we're going to briefly touch on 2 others. And I will turn it over to Bob to start us off.
All right, thank you, Josh. Josh's going to talk about what the actual changes to the board bylaw were. But this particular one, most of our changes really stem from changes in code, new bills that have passed, those kind of things. But every now and then there's a case that comes along that really changes the landscape or requires some clarity in board policy. And that was the case with closed session. It was at least the impetus for why we started our change. Here it was a case, Fowler versus City of Lafayette. It was actually a 2020 case that dealt with the Brown Act. And so I'm going to give you a little bit of background on that, and Josh can describe exactly what the changes were to the policy. So Fowler was actually kind of a classic property dispute between neighbors. It involved the building of what was described as a pool cabana, but it was really actually a fairly substantial pool house. They were seeking permits from the city to do this addition to their property. Of course, the neighbors didn't like the addition, it blocked their view, all the typical neighbor dispute kind of things that happen. And so this kept going back before city council. In fact, it went back 4 times in various stages during the approval process. Some of those were in closed session. Some of them were in open session. Most of it was done in open session. But what ended up happening during the process is one of the parties threatened to sue if they didn't prevail in the process. So they were saying essentially if the city doesn't approve the permits, then they were going to sue the city. And they made this threat orally outside of the meeting. It was documented by the city. And they documented in an online system or a computer system they had that was available through the city's planning counter. And so when this came up, as you probably all know, under the Brown Act, you are allowed to go into closed session to discuss pending litigation. And the Brown Act defines exactly what pending litigation is and gives you 5 scenarios where this actually counts. And this falls into that scenario as a threat made by an outside entity or a threat made by somebody outside of a public board meeting, a statement threatening litigation. But when you go into this closed session, you have to describe what that threat was. In this case, what the agenda noted was the threat was made, and you can go and contact the city's planning counter to find out more of the details. So the parties ended up suing after this threat was made through their process. The city ended up approving the permits. Construction began. The neighbors sued, saying, "Hey, wait a minute! You met in closed session impermissibly under the Brown Act to make this decision, and so we want to undo that decision." As many of you know, the Brown Act, if one of the penalties for violating the Brown Act is that an act done that violates in violation of the Brown Act can be undone through court action. And so in this case, that's what the plaintiffs sought to do. However, they weren't entirely successful, because when this came before the court, they looked at it and said, you know, you're absolutely right. This was a violation of the Brown Act in the sense that there was a threat of litigation, and the agenda should have described, and the materials backing up the agenda should have provided notice to the public as to what that threat was. Because in this instance, there's no harm in disclosing what the threat was. It was all made out there in the public, so there was no party that was going to be given an advantage. So they should have made the threats themselves, or a description of the threat, available for public inspection pursuant to the Brown Act prior to going into closed session. However, the court also noted that while there was a technical violation of the Brown Act, there was no prejudice that was shown to the parties. And that's an important piece for undoing any action under the Brown Act. You have to show that an act was done in violation of the Brown Act and that the violation of the Brown Act itself actually created some form of prejudice before you can undo that act. In this case, as I mentioned, they'd already been in front of the city council 4 different times. All the parties had had opportunity to be heard. And the acts that they were seeking to have undone was actually the approval of the permit, which had nothing to do with the specific litigation that was threatened in the court's view. So the court found that there was no prejudice and they decided not to undo that action. That's sort of the background of this case and why it was the impetus for why we made the changes to the policy. And I will let Josh go into the background of what we changed.
Awesome. Before I let you off the hook, Bob, so just playing out a scenario. So I'm a board member. I'm exchanging an email with a constituent doing my job, and I say something, or they don't like some decision that the board previously made, and they're going to say, they email me and say, I'm going to sue you because you violated whatever, you broke the law. So that is a situation then where this sort of tweak would apply, where that email, which is a threat to sue, that is made on the record, or sorry, made in writing, but not on the record at a board meeting, that statement would need to be made available to the public in order to sort of notice the fact that this is the basis for closed session. Is that more or less accurate?
100% accurate, yeah. And so you wouldn't have to give the actual statement. Obviously, that'd be accessible through a PRA request, but they could summarize on the agenda why they were going into litigation, saying that we were threatened to sue on X action that was taken by the board, something of that nature.
Yeah. And there is a note in the revised version of 9321 that sort of gives some practical suggestions on how to make it easier, because you know, what is a written threat? Like, obviously you want to consult with your attorneys, with Bob, but there is some sort of nod to the complexity and how to sort of implement this on the ground.
One last thing to add on that real quick, Josh. I think it's also important to remember the Brown Act defines 5 sort of definitions of what existing litigation is. And in some instances, you need to disclose upfront what it is, the threat of the litigation in this case. If there's potential litigation you're exposed to where the plaintiff isn't aware yet, so maybe there's somebody's been injured and there was something on the property that exposed you to litigation, or you're aware of something that potentially creates a lawsuit that the plaintiff is not yet aware of. In those instances, on the advice of counsel, you can meet in closed session with counsel to discuss that pending litigation without having to disclose it. So again, talk to your attorneys anytime you have a threat of litigation before going into closed session, because obviously when somebody's threatening to sue, it's time to call the attorneys.
Great. Awesome. All right. Okay. So we did make some changes to this for clarity, precision, and consistency. And so basically you have 2 exhibits, E1 and E2. And the first exhibit was all about sort of how to add language to your agenda that would allow you to properly notice things in closed session. And then the second exhibit, E2, is all about like whether you report out verbally or in writing, how to do that. But what we found when we reviewed the board bylaw was that some of that language was in the board bylaw. And so we wanted to sort of clean it up a bit. So we really moved all of it. And so it's really all clearly laid out in E1 for, you know, how to write it up in your agenda, and then clearly laid out in E2 for how to report it out either verbally or in writing. We also changed some of the section headers. We pulled apart litigation anticipated and initiation of litigation from existing litigation. There are some overlap with a few others. Many of these are ones, I don't know many, but some of them are ones that either hopefully you never use or you rarely use. My personal favorite, I'll just note, is the review of assessment instruments. Boards have the ability to review assessment instruments, but they need to do it in closed session. Otherwise, you're going to know what the assessment is all about. So I always thought that was an interesting, basis to discuss things in closed session. But the other ones are things, personnel matters, negotiations, student matters, things of that nature. Pretty straightforward But you're going to see a lot of sort of red lines just to sort of make it read more clearly. All right, then we're going to go on to this one. So this is an AR only. It makes some changes in light of SB 1057. That particular change focused on exempting certain special education advisory committees from the full Brown Act, but it does require compliance with mini Brown Act, which for the most part is going to keep you pretty similar. So public meetings, public comment, 73 hours notice. You can only take actions on the agenda. And if you violate things, you need to reconsider the next meeting. So not as stringent. There aren't the same kind of sort of crazy consequences, but basically the idea is still the same. Keep things transparent and open to the public so that they know and can engage and can be aware of what's going on. All right, and then we have waivers. So this is 1431. This was SB 114 was one of those major ones that changed a lot of things. So there are certain things that the district can no longer request waivers for related to kindergarten and TK. And then CDE made some changes to its general waiver request document about sort of when you must, share notice of doing so. And that is reflected there as well. This is also only a board policy. And with that, we will back to you, Barbara, for questions.
Yeah, so it does not look like we have any questions on this section in and of itself. We do have some questions at the end, but before we get there, let's go to the next slide, please. There's this one more poll that I talked about at the beginning that we would like to take, which gives you a chance to evaluate us. And we're always striving to improve our services to meet your needs. And this will give us valuable information in working towards this goal. So we really appreciate your time to provide your input. So Josh, if you could please open the chat.
It is open.
And so here's the poll. How would you rate this webinar? 5, incredible, 4, really helpful, 3, good enough, 2, barely okay, or 1, not worth my time. And we appreciate, we will go through, as I said, we want to do what we can to serve you the best that we can. Just because we're getting a little bit close to the time, while you guys are continuing to put your evaluation of us into the chat, let's go to the next slide, which shows our contact information. So if you have any additional questions or anything related to CSBA policy under legal services, you can reach us here. And now we will get to our final Q&As. So we do have some questions here. Let's look at the first one. It says, my district is new to CSBA's Policy Plus, December being our first packet. I understand the updates happen on a quarterly basis. What months should we expect to see those? Okay, so that's a good question. And I appreciate it, especially as as being new. So 4 times is correct. And it would come out in, if we go chronologically from when a new year starts, January, it would be March, June, September, and December. Okay, our next question. I love the overview of policy updates. Will this continue for each update? Yes. So as I just said of when the packets will come out, about towards the end of that month, we typically will have a webinar on it. This one is a little bit different because of the holiday season. So January is when we do our December packet, but otherwise we try to keep it within the same month of the release of the packet. Let's look at question number 3. So this is in regard to SB 114. When can districts look forward to receiving the provided opiate antagonists from the county offices of education?
I can answer that, Barbara.
Okay.
Commencing with the 23-24 school year. The funding should be available from the state. So county offices next school year.
That will be great. It looks like this just is paying for them themselves, so it'll probably be very appreciated. Okay.
I'd just chime in on that real quick, just to know, you might check in with your county office, because the change in the law specified when appropriations from the budget would happen, the state budget, to allow that funding to county offices. Didn't specifically say when the county offices would be providing that. So when they get the money, they'll be providing it. It's probably best to check directly with your county office.
All right, and this one relates back to a former question about the high school graduation requirements policy and if there would be an exhibit. And it sounds like it would be helpful to have an exhibit that could be included in a high school planning guide. So we will keep that in mind as we look through our policy writing. Okay, this question goes back to BP 6142.8, which is comprehensive health education. And the question is, can you clarify the opt-out provision not applying to instruction related to certain topics such as gender identity or gender expression?
I'm happy to take this one, Barbara.
Great, thank you.
So there is an opt-out provision for parents and guardians to excuse their children from lessons about comprehensive sexual health and HIV prevention education. But that opt-out provision does not apply to instruction or materials outside of that context of comprehensive sexual health education or HIV prevention. And so parents cannot opt out their students from lessons that may reference gender identity, sexual orientation, discrimination, bullying, relationships, or family. So as an example, you can opt out your child from comprehensive sex ed, but you could not opt out your student from a history or social studies lesson that is teaching about the 2015 Supreme Court ruling about same-sex marriage. So I hope that was a helpful answer about those opt-out provisions.
Yes, thank you, Megan. Next question. I know I'm going a little fast. I just want to make sure we have time to cover the questions. Could you provide the red line versions of the district policy updates to county offices so we can see the changes made to language the district policies COEs have adopted? I thought we did, but maybe we don't. So that is something we can look into. If we are not doing that, in terms of the red line changes, yeah, I know on Assembly we do post them for county offices, but that would not have the redlining to it. And I know the ones that we do unique for counties do have the red line. So honestly, going to need to look into that. That part shifts a little from my responsibilities to when the packets actually go out. But everything is our responsibility, my responsibility. So we will make sure that question gets covered. So it looks like this is the last question. Do you need to accept the updated policy in order for the updated education code legal references update? For instance, when you have modified your policy to be specific to your district and then edit your existing policy to add CSB updates, how did the ed code legal references get updated? Or do you accept CSB updates and add back in your district specific information? With the updates, if you're looking at our updates, the policy reference section, if I'm understanding this correctly, should be updated also. And it will be updated in Assembly across any document that applies to that same number. So let's say, let's do like 1312.3 uniform complaint procedures, because that it has a policy, an AR, and 2 exhibits. So if we update the policy reference section in the BP, that will apply to all of the policy reference section for all of those documents in that with that number 1312.3. I'm not sure if that answers the question exactly, but if not, please email us and we'll provide a better answer and with more clarity if that doesn't specifically address the question.
And Barbara, what email address should somebody use? You want the gamut or the policy question?
I think they normally go to policy. Yeah, I think that would be great.
So we're definitely doing our best to answer questions. Sometimes, we may misread or whatever. So if
Yeah.
for some reason your question still stands, please email us. We check it, daily.
Yeah.
And I definitely want to make sure that we're getting you the right information.
Right. Or even if something comes up after, if you think about, sometimes I know I attend things and then about an hour later, I'm taking a walk and I think, oh my gosh, I wish I'd asked this question. Feel free to send it right along. Anyway, so we are just about out of time. Thank you so much for attending our highlights of the December packet. And as part of our quarterly sample policy update series, we really hope you enjoyed it, found the webinar to be informative and helpful, and we hope you have a great rest of your day. Okay, thanks so much.